Yes,
I'm for petition.
I'm for sole respondent, Your Honor. Here, I may give some more time to file a retention. 4 week, Your Honor. 3 week, Your Honor. May, yes, always.
On 28th of May.
Oh, that's sure.
My lord, I beg to mention one ABL unlisted. Yes, Your Lord.
Please, my lord, I beg to mention item number 16, my lord. I'm for the respondent, my lord. I'm praying for 4 weeks time, my lord, to file affidavit in opposition, my lord. Yes, my lord. Yes, for 4 weeks, my lord. Affidavit in opposition, my lord.
Yeah, my lord. I'm appearing on behalf of petitioner, on behalf of leading counsel K lawyer. K lawyer is out of station. So item number 14, my lord. Maternal list after 3 weeks. My lord, there is an interim.
Not item number 6 and 7. I have this question of mental liberty. Today is last day of the week. So may I pray that this will be taken up on 14th. 6 and 7, yes.
My lord, this revision against the imping order passed by the Larned Special Court POCSO, where application was filed for examining of remaining 2 defense witness for the accused, it was rejected. Application was filed before the Larned Special Court, praying for examine the defense witness, remaining defense witness. During the time of 313 examination, accused deposed before the court that he want to examine defense witness as a 5. And on the past day of defense witness, accused produced 3 witnesses and remaining 2 witnesses left. And for that application was filed for examine remaining 2 witnesses, but Larned Court below denied. Page 22. Titorum. Four four two and 438. Yes.
During the examination of the accused under section 2 CRPC, he expressed his willingness to reduce examine himself and four more parts of the subsequently, he examined himself as PW1 and also examined PW2 and PW3. According to, as per the order to do, in the admitted position that two persons applied for summoning two other defense witnesses by the court. Primarily, the learned system that has received the prayer of the petitioner to reduce two additional witnesses, particularly on the ground that there is a delay in the trial and the FIR was lost on 20, started them on 28/6/2022 and we did the prosecution could not be completed. The prosecution could not be completed. And different sort of adjournments on earlier occasions reduced the eligibility of the subsidiary could not produce results. And that the case is fixed for hearing on final argument. This court is of the opinion that this petition will be disposed of as a responsibility without extreme issue is that the parties. In advances, the considered opinion of this court, the learned petition that is communicated around by not allowing the defense to reduce the additional witnesses. It is a second proposition of the law, right of defense by giving the individual to right. In response to violation of Senate, which is the right of the person under the that we cannot ignore the fact of the concern of the learning system that for early disposal of the prosecution. However, since there not be at the cost of right of in view of the opposite, the improved order is very fast. The petitioner is permitted to reduce evidence, however, unnecessary, however, the petitioner if he self-compare unnecessary observation and in completely by 2 months.
Your Lordship, I'll just explain, Your Lordship. And that's like under 256, the accused has to take the process of someone, Your Lordship, which he has not done. That has to be done by him in the meantime.
Among the agencies, the learned magistrate says the learning system that divided part of this.
Diffuse.
Then we stay on.
Yes, 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 yes.
Highly obliged.
Final.
Date.
$16,500.
May it be please. Also, this is a revision petition. Lordship, what happened here? There was a money issue, and in the money issue, there was a judgment was passed. Accordingly, the petitioner applied for execution of the judgment, but as the degree was not prepared by the then additional district judge, the judgment could not be executed, and I was bound to, the petitioner bound to withdraw the execution application. And for that, we applied for preparing an application under section 151 CPC, but the learned court has by an order 10/2/23 has rejected, saying that it has been delayed and some other grounds. S-tire. Yes, I am ready. Money issued 18 of 2015. The judgment is in page 20, annex 1. The below PS money issued.
The judgment and decree was passed on 26/7/2017.
Yes.
The petitioner, where the high and execution petition, which were registered as
One of 18. Yes. So in the orders, annexer 2, page 41.
during the course of execution, it was brought to the notice of the land executing board that judgment was passed, judgment and decree was passed, however, decree was not drawn. Accordingly, the executing court, presiding judge of the executing court, declined to draw a decree on the ground that the same presiding officer did not pass the judgment, and therefore he cannot draw a decree. The decree is drawn by the officer.
Yes. By last of this month.
30th of May 2025.
My pleasure. Marat, before submitting Marat, the new development, Marat, as per the So Honorable Supreme Court has transferred the whole case to the Kamrup jurisdiction of Assam.
Yes, Your Lordship also wide notification 27. Since this is a subsequent bail application, Your Lordship, on the earlier occasion, Justice K. has disposed of.
In my case, do the trial for trial the matter. Yes,
Bail.
Malad. Yes. Yes.
Yes. Yes. Yes.
Yes.
Otherwise, yes.
Yes, but just in case is it
Yes.
will be better, man,
Yes.
because otherwise it would seem that I have not informed the court regarding that matter.
I'm for the informant in this, my lord, if my
No, but-
appearance will be marked. I was the petitioner in the Supreme Court, my lord, in this matter.
Yes.
This is not.
My lord, item 5, I'm for the informant.
Not second bail application. This is for 483 first bail application. Under 483 first bail application.
That was Justice Atta, sir. It is
Yes.
in respect of him in AB, Your Lordship.
AB.
AB. This is
Yeah.
subsequent.
Regular bail.
Regular. It speaks about if bail arising from same FIR, it will be. No, Your Lordship. Yes,
Yes.
no, Your Lordship, yes. It's the
Granting or rejecting, pass bail order granting or rejecting, passed by the bench. The all OAQs, if to come, now that is gone.
yes.
Now, so far in this situation,
Sub-
the application filed by a petitioner is rejected by a bench.
Yes.
Even the second application, maybe 80 or
Yes.
is to go to that one in a
Bench.
if necessary to partial.
Yes, Your Lordship, yes.
This before as in terms of notification number 27.
It
20
says if it's sitting some other benches, it would not.
Can be partially, you can see last body.
Yes.
27 days,
3rd of May.
third of
May 2025.
The
Obliged.
Hello, this is a civil revision petition, civil revision petition. For against the decision, Kawang decision passed by the village authority. The village authority. Mr. Sanjay is here. My case is very simple, Malad. I am praying for enforcement of para number 4 of the judgment. Without taking any evidence, Malad, without recording statement of any, Kawang decision was passed. But a right was given to me, Malad. Page 23, Malad. It is the translated copy, Malad. Page 23, Malad. Page 23 of my civil revision, my lord. My lord may come to please amended civil revision petition, my lord. Yes, my lord. CRP 11. CRP, yes, my lord. CRP. Yes, my lord. Page 23, my lord. Of CRP 11, my lord. Yes, my lord. This is, may I read the this? I am, my lord, Abhyad Dai, my lord. Yes, yes, my lord. Now may I read, my lord? Today dated so and so 19 with the village dispute in between Sri Tamutasang Boeing village and Sri Obvious Day so and so. Dispute at 7 mile has conveyed under the customary code. Sri Otet Rugbo so and so.
You are Obed Dai, isn't it?
I am Obvious Day, yes, my lord. Was sitting as chairman of the said. In the said, Sri Obvious Day was absent. Therefore, the gated persons after.
Just a minute, just a minute. So paragraph 4,
Yes, my lord.
you are allowed to ask, recall the kebab.
Yes, my lord.
Now you have recalled.
Yes, my lord. Page 25, my lord, is my application on 28 to 2021. Translated copy is page 26, my lord.
25. Norm so, okay.
Yes, my lord. 26. This is a translated copy, my lord. Within 10 days, my lord, I have submitted my application for, my lord, for quashing aside, my lord.
Then what happened?
Then, my lord, this page 27, my lord. The translated copy, my lord, it is page 28, my lord. The village authority, my lord, refused to reconvene the kebab, my lord, since I have not prayed for reconvene of kebab, but only for quashing of the kebab. Annulling of kebab, my lord, and recalling same thing.
So therefore, within 15 days, you have not called the kebab. This is the reason.
My lord, my interpretation is that, my lord, I have, my lord, on, my lord, may please see.
Oh, forget about that.
Yes, my lord.
What is the difficulty in giving him a chance?
Yes, my lord. I
That's
need a
all.
trial, only trial, my lord.
It's a right.
Yes.
For only a thing that it is not that he is seeking, challenging the kebab decision. What he's saying that please recall now, I will
Yes.
do my thing. Allow it.
Your
I want to
lordship,
participate.
your lordship, there is the contention in the application. He is just intimating in the page 26. Just he's informing about the FIR lodge before the police station
Maybe he has lost an affair.
and saying that you was the kebab. And
See, your difficulty is that instead of coming to us, why have you gone to police? This is the ego.
Yes.
Is that it?
And moreover, I have raised the issue of maintainability of this application also. That
We'll admit this. What is the status of the on that land?
Land, my lord, there is an interim order, my lord. This is for disposal.
Continue. Admit this with application. Call for the records of the kebab decision of
Yes, my lord.
this short method we could have disposed it of. If you
Yes.
want to argue, we'll hear it. Admit this application. Call for the record pertaining. Where is the decision?
Decision is at page 22, my lord.
Page 22.
Yes, my lord.
Relating to the kebab decision dated 19 to 2020 held for resolution of dispute between the petitioner and respondent. By whom? By which kebab? Which village?
Boeing village, my lord.
Of Boeing, kebab of Boeing village.
Yes, my lord.
Kebab of Boeing village. Who will call registry?
Yes, my lord.
Registry will call so and so. Admit this revision petition for hearing. Call for the records of so and so. As the parties are duly represented, no formal notice need be issued. List on.
After a week, my lord.
After 2 weeks.
Yes.
Give a date because it's a question of record. And what is the second CRP?
Second CRP, I have challenged the execution petition, my lord. The execution
Okay,
petition.
okay, that's.
There's a stay, my lord.
Full stop. This is done and next matter, list this matter along with CRP 11 of 2020. Yes. 10. Date,
my lord,
both of you,
30 May.
38th of May.
Obliged.
What is this? Affidavit file?
Lordship, yes, we have filed.
Okay. Now you have, he has deposited 1 crore.
Yes, Lordship.
Now regarding 2 crores,
Lordship.
what is your stand?
Lordship, we have mortgage. Lordship, my senior is on fees.
Yes,
Yeah,
Mr.
please,
Sir.
On the last occasion, your lordship was directed to file affidavit. And we have filed the affidavit showing the deposit of rupees 1 crore.
That's
That is
fine.
phase 1.
They have also
That is
not
one.
disputed it.
No, but this was filed before filing of this petition.
Before filing, but
Yes.
courts wanted that please give a proof.
yes.
That has been given. There is no dispute.
Yes.
Now, so far relating to 2 crores, they want some time.
Yes, but
Is-
your
is that
lordship
it?
can see your lordship can see page 143.
No, we are not, we will not see anything. Give your proposal.
No, my lord, I have made an advertisement of sale of my land.
No, we understand you are in difficulty. We could not sell the land, but you want to pay. Give a tentative kind of thing. We are not throwing it out today, but at least assume
My lord,
something.
my lord, I can assure you, lordship, that I can deposit 30 lakhs within a week.
Okay, you deposit 30 lakhs within a week, no problem. Then after 3 weeks, you just give us a concrete proposal, taking note of your situation, difficulties, when can you pay? That's all?
Yeah.
Okay.
Okay.
Mr. Sharma, learned, S.C. Sharma, learned senior counsel, assisted by Mr.
Titaba, yes.
T.
Taba.
Taro.
Taba.
Taba, T. Taba. Teto Taba.
Yes, Lordship.
Okay. And Mr. Tafo, learned standing counsel for Arunachal Pradesh State Cooperative Apex Bank Limited. Mr. Sharma, learned senior counsel. Senior counsel referring to this court's earlier order dated, where is that 2 crores business? 2 crores business?
25 to 2025.
25 to month.
25 to, no?
Yes.
Referring to this court's order dated 25 to 2022. Submits
25.
that, to 2025, submits that to the petitioner was willing to deposit an amount of rupees 2 crore against the due to the bank with an expectation that his land will be sold out. However, the same could not be materialized. Accordingly, he submits that he may be granted some time. However, to honor his commitment, the petitioner will deposit an amount of rupees 30 lakhs within a period of 10 days.
Lordship.
Okay?
Yes, Lordship.
10 days within a period of 10 days. Considering the intention of the petitioner, this matter is adjourned and be fixed on after 10 days.
After 4 weeks.
No, but no.
After 10
Sure,
days.
yes.
No, we are fixing 10 days. We'll give 4 weeks. That is a different thing. 10 days. 23rd of May. 23rd of May, on or before the said date, the petitioner shall file an affidavit giving proof of payment of rupees 30 lakhs as as submitted, full stop. Thereafter, this court will consider for further extension of time for payment of the remaining time, depending upon the situation and difficulty of the petitions. On that, they will consider, okay?
And, there are two items, man. Item number 17 also. Man.
What is 17?
Same, man. Amounts are different. One is 10 crore, one is 6 crore.
Now, in this, you want to give 30 lakhs in both.
Yes, Lordship.
Okay, let us be
30 lakhs
together.
in-
List this matter along with CRP 16 AB 2024. See, you want money.
Yes, man.
He is having difficulty. Let us see if we can resolve it in
Yes,
this way. Why should
Yes.
Well, the interim order may be continued.
interim order pass earlier shall continue till the next date of list.
Highly, highly of this.
But file the affidavit.
Lordship.
Okay, we'll try.
10-11 is adjourned, no? Oh, this is done. Yes, Mr. Tama.
Well applicated, Lordship. This,
Bail
first of all,
application
I'm praying
during
for-
investigation or after search sheet?
no, Lordship, investigation is going on. This accused is inside the jail. It's about to be 4 months. Number one.
Under
number-
section?
under
NDPS,
section,
man.
NDPS.
27
And
years.
number two, I have filed this application on the ground that there is an illegal arrest. Because a mandate of law under Article 20, this ground of arrest has not been given. He was just driver. No ground has been given. And
Now, where is the
on
affair?
basis
Where
of
is the
that-
affair?
On the basis of that, this co-accused has been already released on bail. And I have enclosed the judgment, Justice Kadak has already released the co-accused on bail already. That is why additionally I am praying for parity of law.
Then in that case, this case has to be listed before the concerned judge. Anyways, but this is not the successive one.
Kindly see, Lordship,
12. But page 12 is the FIR. And on page 12, yes, FIR. Annexure 1. 27
Where is the case that?
it is with me, Your Lordship. Please keep. Now, Your Lordship, here, Your Lordship, the issue is the earlier.
Who is the owner of this cannabis? As per
Your Lordship, actually, they.
vehicle belongs to whom?
Vehicle, Your Lordship, here actually, Your Lordship, their bail application, if Your Lordship will consider, Your Lordship, they have only come before this court, not challenging the merit of the, not on the ground of merit, only on the ground of the violation of Article 22(2) of the Constitution of India and violation of Section 50 of the Act, Your Lordship, CRPC, Your Lordship, for non-communication of the ground of arrest, Your Lordship. In earlier also, Your Lordship, one of the co-accused has approached this court and this honorable coordinate bench has granted bail on that ground, Your Lordship. Because of that, Your Lordship, recent judgment of the Honorable Supreme Court behind, Your Lordship, that creating lots of difficulty, I shouldn't.
What is? Not get jails are now empty.
Yes, Your Lordship. But, Your Lordship, we are expecting that in the subsequent one, Your Lordship, which has been taken up by Justice Gawai, Your Lordship, that perhaps the judgment will clarify every aspect, Your Lordship, whether it will be applicable to all the cases or not.
If death is in only the same ground,
Yes, Your Lordship.
so let him go 4 months.
Yes, Your Lordship.
my
No way
wife
out.
is pregnant at
Huh?
this stage. I have enclosed this,
Your wife.
yes. It is
What
about
is
to be
it?
delivered.
Your Lordship, 12 and 13, same, arising out of same FIR, two accused. And the ground.
Only name will be changed.
Yes, only
name
name will be changed.
Huh?
And for non-compliance. And Your Lordship, in this case only, Your Lordship, in arrest memo, the reason of ground of arrest is missing, Your Lordship. In other is there.
Okay.
In other
But
cases,
here it is says no ground of arrest.
yes, my lord, your lord, my lord will find in
In
the
this, in Mr. Tama's case also, there is no ground of arrest.
ground of arrest is not shown in the arrest
And
memo.
in this case, Sikha Soikia, there is no ground of
Yes,
arrest.
your lordship.
So it will be similar. Others were not coming.
Yes, your lordship. Only in the CD it has been
Third,
mentioned.
Mr. I will not pass the detailed order, but I will pass in this manner. Just listen to me.
Okay.
Mr. Tama, learned counsel. Titapak, sorry, Titapak, learned counsel for the accused petitioner, and also heard Mr. Ete, learned additional public prosecutor for the state. This application under section 483 of BNSS 2023, you can take paragraph 2 of the earlier order, page 30, okay? Only name will be changed. What is your name? Accused is
Sibadas.
huh?
Sibadas.
Sivadas.
Yes.
Just like see the name. In connection with Doimuk police station so and so has been arrested on 10/1/2025.
Yes.
The up to paragraph 4, it is same. Okay. The coordinate bench in BA/34/2025 filed by co-accused Sikha Sharma.
Sika was wife, your lordship.
Dan
Dan Sharma.
Sharma.
Huh?
Accused is Dan Sharma. Wife has filed. Sika is wife.
Accused Dhan Sharma. Oh, sorry. Accused Dhan Sharma taking note of the determination made by the Honorable Apex Court in Probir Purakayastha versus State within bracket NCT of Delhi, reported in 2024, 8 SCC 254. What is the judgment? Probir Purakayastha. What is Bihan?
Bihan, your lordship. Purve Prakasto was
And
Bihan.
And in Bihan Kumar versus State of Haryana and another, reported in 2025 SCC online SC 269, granted bail to the said accused in the same who is an accused along with the petitioner in the same police station case. Granted bail to the said Bihan Sharma in the light of the judgment of and the order of the aforesaid Apex Court judgment, more particularly for the reason that the police has failed to furnish the grounds of arrest to the accused, is in clear violation of Article 22 within bracket 1 of the Constitution of India, although the offense alleged is serious as same pertains to NDPS. Mr. Swenso, learned counsel for the petitioner, submits that the petitioner is exactly similar to the aforesaid accused person. Rather, he was the driver of the vehicle. You are the owner of the vehicle?
Driver of the vehicle.
Oh, who is owner?
Owner is not mentioned by the.
Owner of the vehicle, and he was not aware of such possession and aware of such aware that cannabis were in the vehicle. Be that as it may, this court has perused the materials available on record and also taking note of the order passed by the coordinate bench in the same background and similar material. This court finds that parity demands that petitioner shall also be granted bail. Accordingly, so and so, then paragraph 13. Okay. Then you give the conditions like yesterday you've given
Yes, Your
the
Lordship.
conditions.
Obliged.
But it is a debatable issue.
Yes,
So
absolutely.
far relating to NDPS.
Yes, Your Lordship.
I have granted it, but it is debatable so far. Where is the 37 will go?
Yes, Your Lordship. That aspect has been discussed in the earlier the new which has been reserved by the Honorable Supreme Court. That the police cannot be expected that the person who is carrying a gunny bag and go back to police station and come with the ground of arrest. So this is yet to be, Your Lordship, come out the judgment. It has been reserved. Your
Because
Lordship.
see, this is a 30. Otherwise, it will create a difficult.
37 become redundant, Your Lordship.
Redundant, and it's a special law.
Yes, Your Lordship.
Should we pass an order and refer it to the larger bench?
That can be done.
Whether making an issue can be made applicable in section 37.
Only, Your Lordship, difficulty in the Vihan case, what it has been clearly, Your Lordship, reflected by the Supreme Court that no any statutory bar will also operate when the ground of arrest is not been communicated on that aspect.
Anyway, today it is gone, but in a sense, if it sense comes to me, I will deal with it.
Yes, Your Lordship. Absolutely. Yes.
Because today it may not be possible. Anyway, you are in citizen. Yes,
Obliged. Same 13 also same. Your Lordship.
13 same.
Only name different.
Name only different. Why this matter is listed?
My lord, in this case, appeal has been preferred against the conviction under section 376(2) F IPC.
Who is respondent number 2?
Your Lordship, on the earlier occasion, the court, though the service was completed, the court had waited for if they will be appearing or not, Your Lordship. Otherwise, Your Lordship can appoint an amicus to.
Okay. The present appeal is filed against what is that?
Order dated 15/9/2022.
Order judgment and order dated
15/9/2023.
15/9/2023
Yes, ma'am.
passed by learned session judge Lower Subansiri / Urung Kume / Kra Dadi / Kamle districts in session case within bracket Z number 04/2022, whereby the accused were acquitted.
No, Your Lordship, convicted.
Accused were convicted. Accused appellants were convicted for
Offense under.
Offense under section 376(2) F IPC.
376
2 F IPC.
2 within bracket F IPC, and were sentenced to
10 years.
undergo rigorous imprisonment of 10 years. The notice upon respondent number 2, the informant, the victim, informant, has duly been served. However, none appears for the said respondent number 2. Accordingly, registry to appoint an legal aid counsel / amicus curiae to represent respondent number 2, Christoph shall furnish the and prepare a paper book.
Paper book already prepared.
Christoph and furnish a copy of the paper book to the amicus curiae and list this matter after 2 weeks.
After 1 week.
After a week.
Yes.
Your Lordship, after a week, because.
No, after a week it will come, then we'll have to fix it for hearing. Okay, whether copy is served or not.
Obliged.
May I please, Lordship?
Yes.
Lordship, this is a matrimonial appeal filed by the petitioner challenging the divorce decree issued by the learned District Court, UPA, by order dated 24/2022. Lordship, here in this case, along with this.
Why this matter is listed?
Lordship, today the matter is fixed for hearing on IA number 76/24.
What is IA?
Which is, Lordship, under section 5 of Limitation Act. Yes, because Lordship.
How many days delay?
600, more than, Lordship 600,
Objections filed?
Lordship, I am going to file mine.
You want to object, file objection or do not object?
Lordship, may I kindly give a short answer?
Lordship.
Actually, the respondent is residing in Gujarat, Lordship.
Ah.
He is unable to come. So, need a short answer.
Lordship, Lordship in that,
No, otherwise it would have been 100, within 100 days, I would have condemned without hearing any. But
Lordship-
600 days.
Lordship, it's 752. Actually, they have wrongly written.
Anyway, that you take
Yes,
in
yes,
objection. See, I understand your anxiety, but the only problem is that, but we'll give you a last chance.
Lordship.
Lordship short date, 1 week.
Though the respondent entered appearance on 18/12/2024. However, no affidavit, no objection has been filed opposing the prayer for condonation of delay of 600 days. Full stop. The learned counsel submits that he may be granted a last chance to file such objection. Considering prayer stands allowed.
Lordship 663 days.
Anyway, 663 days. Prayer stands allowed. Accordingly, list this matter again on.
Lordship fixed date.
Lordship, any short date.
You tell, when can you file?
Lordship, after a week, Lordship.
You tell me the date, when, by which date you will file it.
5th.
Such objection be filed within 15th of May 2025 and thereafter list this matter on 17th of May. Hold on, then next we have 19th of May. For consideration of the prayer of, for consideration of this IA. Yes, what is this?
Service upon respondents have been completed.
Service is completed?
Yes, my lord.
So,
And I filed an affidavit bringing record the DAC receipt and screenshots of the service completed.
so dusty service.
No, by registered post.
So this has been
Completed. It was
completed.
received, yes, it was received in the month of February. And it seems the parties are not interested. The respondents are not interested. Therefore, it may be fixed for admission hearing.
Where is that your affidavit?
File.
The petitioner has filed an affidavit showing service of notice upon respondents by way of registered post. Full stop. The track consignment report shows that the the notice was booked on 4/2/2025 and it was delivered on 6/2/2025 at 15:41 15:41 hours. And what is this? Twice you have taken.
No. That is the five respondents.
No, not necessary. Has submitted track consignment report, which goes to show that notices were delivered to the respondent parties. Such affidavit was no directed, however, accepted, and it is seen that service is accordingly service upon the private respondents are accepted. List this matter in the admission column.
On short,
After 2 weeks, let us see.
after week.
After a week, give a date. 15th of
Much
in the
obliged.
admission column.
Much obliged.
Okay.
19.
What is this? Why this matter is listed today?
This is relating to compensation, madam. But the instant IA is relating to condemnation of the.
None appears for the applicant.
Yes,
Office note dated 7/5/2025 reflects
my,
that,
my lord, just a second. My lord, the compensation I have already received.
okay,
Yes.
just the seven, you are respondent number
One.
one, okay. Reflects that unserved notice in respect of respondent number two has been returned with a postal note within bracket insufficient address. Full stop. And service report in respect of respondent number three is not yet received. Full stop. None appears for the applicant and all call. However, the learned counsel for the claimant submits that the amount awarded has already been received by the claimant.
And the matter has become infructuous.
Claimant, not infructuous, they may, okay, claimant. In the considered opinion of this court, the same may be the reason for non-appearance of the learned counsel for the appellant. As the learned counsel for the appellant is not present, this matters and no steps has been taken, no press steps has been taken upon respondent number two. This application stands dismissed. Dismissed for non-prosecution. In MSC appeal, you write down, in view of order passed in IAC 61 AP 2020, passed today in IAC 61 AP 2025, MSC appeal 4 within bracket AP of 2025 stands closed.
Okay.
So all IA and L closed.
This criminal petition, lordship, kindly see that this matter has been filed on the ground that the matter is of civil nature. First ground. Because
your conduct is absolutely bad.
Next case is
Adjourn this matter and list after 3 weeks.
I will play previously case study also, lordship, because in the bail, lordship, he has not.
I've seen
Yes,
he
lordship.
has not disclosed anything
Yes,
that
lordship.
he has filed IA.
Yes,
this is
lordship.
that. Okay, next.
After 3 weeks, lordship.
After 3 weeks.
Yes, right, lordship.
Mayor Lordship,
I have not, yes.
this is a matter of 2019. We have made an appeal.
Lordship, I'm seeking for
This is a second
adjournment.
appeal.
You are,
This is a second appeal.
huh?
Mr. Deepak,
I am in his favor today. You want an adjournment?
yeah, Lordship, Mr. Deepak out of station.
He's out of this.
No, my lord, my point is that
No, I understand, but I'm in his favor today. Absolutely in his favor. For the adjournment.
yeah, my point is only that this matter has been fixed for the final argument in the court list. But
Final
it
argument.
still with the paper book has said LCR has been called for, but the substantial question of law has not been drawn. And I'm not going to argue the entirety of the appeal, but I'm going to say, insist before the court that
Okay, next week, when, tell us.
substantial question of law is to
2
be
weeks.
drawn.
Yes, huh?
Lordship, 2 weeks.
Not 2 weeks, before that.
Or Lordship, 1 week.
1 week, give a date. We are fixing it yet, as per your convenience, give a date. May 16th.
Your Lordship,
It is seen that though the appeal is admitted, paper book is prepared. However, no substantial question of law has been framed. Where is that? Nothing has been framed. No, framed. See, 15/7, 1, 2, 3. 1 and 2, 15/7/2019, substantial question of law framed.
15/7.
15/7/2019. The second appeal is admitted hearing following substantial question of law 1 and 2 Entries further formalization of law is kept open. That may be during hearing. Okay, on 16 for hearing,
16 May.
16 May.
Okay.
Okay, 16 May. Substantially, don't write anything. On the prayer of Mr.
Sita Jo.
C. Tajo appearing on behalf of Mr. D. Panging, Learned Counsel submits that Mr. Panging is having some difficulty. Accordingly, he prays for an adjournment. On the other hand, Learned Senior Counsel for the petitioner expresses urgency as this matter is pending since 2019. Accordingly, list this matter on 16th.
All right.
Lordship, here stay already granted, so since then they are not appearing.
Why? Criminal appeal against conviction.
Yes, Lordship.
None appears for the appellant on call. None represented the appellant when the matter was called on 6/2/2025, 6/5/2024, 22/8/2023. In view of the aforesaid, registry to appoint one amicus to argue this case. List this matter after 2 weeks.
Right.
Both the 24 and 25? Huh? Okay. That was 23?
Yes, Lordship. Lordship, this matter pertains to the
How many witnesses?
witnesses, Lordship, 8.
Today may not be possible to dictate a judgment.
Lordship.
Give a date. Criminal appeal dictating, delivering a judgment in the court. It's not so easy. Tomorrow we are leaving.
Yes, Lordship.
Give a convenient date. Don't fix it on Thursday. Fix it on Tuesday. At least we have 2 days time to dictate and deliver a judgment.
25th of June, Lordship.
25th of June. 24 and 25 on the as agreed to by the Learned Counsel for the parties. This matter on 25th of June.
Obliged.
What is this against? None appears for the petitioner on call, so MSL Learned Counsel for the additional public prosecutor is present. Please this matter after 2 weeks, after 3 weeks. List it tomorrow. Ask the registry. I will be busy with some work. Just immediately ask the registry not to prepare list. Ask the council to list it tomorrow.